Welcome to this session on research methodology. Today, we are going to explore a crucial topic for any aspiring researcher: how you can protect your hard work and original ideas using copyright and patent laws. Whether you are writing a groundbreaking thesis or inventing a new technology, understanding these legal frameworks is essential to safeguarding your intellectual property. Let us start by understanding what copyright actually is. Imagine spending months writing a beautiful story or a detailed research paper, only for someone else to copy it exactly. Copyright acts as an invisible shield around your creative output. It is a specific type of intellectual property law that protects the unique expression of an idea, rather than the idea itself. This means it covers things like books, music, and software code. The best part is that this protection is automatic the moment you write down and structure your findings. Now that we know what copyright is, why does it matter so much in academia? Without these laws, the motivation to create and share original works would plummet drastically. Copyright grants you, the creator, exclusive rights to reproduce and distribute your work. This ensures that researchers are properly credited for their hard work, which in turn fuels a vibrant and innovative culture. Most importantly, it protects the integrity of your publications, preventing others from republishing your exact text and claiming it as their own. Knowing that your work is protected leads us to an important question. How long does this protection last? In many jurisdictions, including India, we calculate this using a simple formula. DC equals YD plus 60. Here, DC represents the year the copyright expires and the work enters the public domain. YD is the year of the author's death. The constant 60 represents the number of years the protection lasts after the author passes away. So, if the author lives longer, the expiration year increases, extending the timeline of protection for their heirs. Before we move on, let us see this formula in action with a concrete example. Suppose a famous researcher publishes a groundbreaking textbook in the year 1990 and unfortunately passes away in the year 2015. When will the copyright expire? We know that copyright expiration is based on the year of death, not the publication date. So we take the year of death, 2015, and add the standard 60 years of posthumous protection. This gives us the year 2075. Starting in 2076, the textbook enters the public domain and can be freely copied. While copyright protects how you express an idea, what happens if you invent a brand new, highly efficient solar panel? This is where patent law steps in. A patent is an exclusive legal right granted for an invention, protecting its underlying functional mechanics. It is a special bargain with the government. You publicly disclose how your invention works, and in exchange, you get a temporary monopoly to make or sell it. To qualify, your invention must meet 3 strict criteria. It must be novel, involve a non-obvious inventive step, and be capable of industrial application. This temporary monopoly we just discussed is the absolute lifeblood of modern technological advancement. Patents provide a massive financial incentive for individuals and companies to invest heavily in research and development. For instance, pharmaceutical companies would never spend billions developing life-saving drugs if generic manufacturers could instantly copy them. Furthermore, because patents require you to publicly disclose your invention's mechanics, they constantly add to the world's collective technical knowledge. This allows future researchers to learn from your work and build upon those ideas once the patent eventually expires. Since patents grant such a powerful monopoly, their duration is strictly limited compared to copyright. Let us look at the formula used to determine when a standard utility patent expires. dP equals YF plus 20. In this equation, dP represents the year the patent expires. YF represents the year the patent application was officially filed, which is often earlier than when it was granted. The constant 20 represents the standard number of years a utility patent is valid globally. This means an inventor gets exactly 20 years of exclusive rights starting from their filing date. Now that we have our patent duration formula, let us apply it to a real-world scenario. Imagine an engineering team invents a medical device and files a patent application in the year 2010. Due to bureaucratic delays, it is not officially granted until 2014. When does it expire? A common mistake is to start the clock from the grant year. However, the law dictates the 20-year clock starts on the exact date the application is filed. So we take the filing year, 2010, and add 20 years. The patent expires in the year 2030. So we have established how to protect your work, but how do you actually make money from it? Having a copyright or a patent is like owning valuable real estate. You can rent out your intellectual property to companies who want to use it. In exchange for this permission, they pay you a specific fee for every single item they sell. This continuous stream of income is called a royalty. It creates a beautiful win-win situation. You get passive income without needing a factory, and the company gets to sell an innovative product without having to invent it themselves. Understanding how to calculate these royalties is a fundamental business skill for any researcher looking to commercialize their work. The basic formula relies on simple multiplication. R equals P times R times N. Here, R represents the total royalty income earned. P is the retail price of a single unit. The variable R represents the royalty rate, which must be expressed as a decimal. Finally, N represents the total number of units sold. In plain English, your total income is simply the price of the item, multiplied by your percentage cut, multiplied by how many items were actually sold. Let us put this royalty formula to the test with a practical example. A university researcher licenses a new water filter patent to a company. The company sells each filter for $50 with an agreed royalty rate of 6%. If they sell 10,000 filters in 1 year, what is the researcher's income? First, we must convert the 6% rate into a decimal, giving us 0.06. Next, we multiply the $50 price by the 0.06 rate by the 10,000 units sold. The researcher earns $30,000 that year. To visualize how all these concepts connect, let us look at this intellectual property protection flowchart. At the very top, we start with an original creation. This splits into 2 distinct paths. On the left, if your creation is a creative expression, like a book or code, it falls under copyright, which lasts for your lifetime plus 60 years. On the right, if it is a functional invention, like a machine, it requires a patent, lasting for 20 years. Both of these paths ultimately converge at the bottom into commercialization, where you can license your work and earn royalties. We have covered a lot of ground today, so let us review the key takeaways. First, copyright automatically shields the unique way you express your ideas, lasting for your entire lifetime plus 60 years. Second, patents protect the functional mechanics of new inventions for a strict 20-year period, requiring public disclosure in exchange for a temporary monopoly. Finally, Both of these legal frameworks allow you to safely share your discoveries with the world, while retaining the right to commercialize them and earn royalties. You now have the knowledge to protect and profit from your ingenuity.